Have you ever wondered how to maximize your LLC protections? Do you want to make sure your LLC protections hold up? Have you ever wanted to know what a piercing of the corporate veil is? Have you ever wondered whether a single member LLC really protects you? If so, you're in the right place. Stay tuned for all that and much more.
Hi, I'm William Dolan, and this is Esquire Advice, where we explain complicated and lucrative real estate and business topics. Remember, we are not forming a lawyer-client relationship by way of this channel. Always consult your local attorney before taking any action. With that said, grab a pencil and a piece of paper and get ready to learn.
Welcome to our episode on how to maximize your asset protection with your LLC. But before we get started, please kindly hit those like and subscribe buttons so we can keep bringing you valuable and profitable content. Okay, so there are three primary ways to maximize your LLC protections. First, you need to be sure that your LLC agreement, or operating agreement as it is sometimes called, is well drafted and tailored to your situation. For example, in a single member LLC, you want a provision that waives your fiduciary duties to the fullest extent permitted by law. This will maximize your protections in a potential bankruptcy, insolvency, liquidation, or receivership situation. It would also help you with potential liability that you may have to other members and the company in a multi-member LLC. However, in a multi-member LLC situation, waiving fiduciary duties can also cut the other way. In other words, if fiduciary duties are reduced or eliminated, that would also apply to your recourse against the other members and the company. The appropriate fiduciary duty standard of care can also vary based on the distribution of duties and obligations among the members. For instance, if one member is putting up all the money and not doing much of anything else, and the other member is doing all the work, the capital member would prefer a negligence standard of care, which is the strictest standard. However, the operating member would prefer a more lenient standard of care like gross negligence or willful misconduct. Another provision that you generally want in a single member LLC agreement is that the member has no obligation to make capital contributions. In a multi-member LLC, you may want this provision too, subject to the inclusion of any capital contributions that have been negotiated between the members. All right, so the second thing that you need to do is to make sure you are always receiving fair market value compensation for goods and services provided between you and your companies. This is for fraudulent conveyance purposes, bankruptcy purposes, and piercing of the corporate veil purposes, as we will discuss in just a few moments. Also, you never want to take money out of the company if the company is insolvent or rendered insolvent by such transaction. All right, so the third item we're going to discuss are the steps you should take to prevent a plaintiff from breaking through the LLC shield and getting to your personal assets, which is generally referred to as a piercing of the corporate veil. A similar concept is enterprise liability, which is breaking through the LLC shield to get to the assets of your sister or affiliate companies. Okay, so we're going to cover the 5 operational areas that make up the piercing of the corporate veil factor test that many courts use. A factor test is different than a conjunctive test where all of the elements must be present, or a disjunctive test where only one of the elements needs to be present. Instead, a factor test will weigh the facts present as it relates to each factor and come to a conclusion based on the overall result of the analysis. First, do not commingle assets and liabilities of the company. That means you need to have a separate EIN for the LLC, a bank account for the LLC, a separate policy of insurance for the LLC, a separate credit and/or debit card that you can use for expenses for the LLC. And it also means you have to pay for the LLC's liabilities with your LLC's money or assets. It means you also cannot pay for the LLC's liabilities with your personal assets or with the assets of any sister or affiliate company's assets. So I get asked all of the time, well then how the heck can the company have any assets if I can't use my own money? The answer is simple. I didn't say you can't lend money to the company. I didn't say you couldn't make a capital contribution to the company. What I said was that you cannot pay for the company's liabilities with your assets. If you want to fund the company with a loan, you should have a promissory note drafted, which is executed by the LLC in favor of you. If you want to make a capital contribution, you can simply write a check to the LLC, deposit the funds into the LLC's checking account, and log it as a capital contribution on the books and records of the company. If you're unsure whether you should fund the company with a loan or capital contribution, I would recommend that you discuss this topic with your CPA to see if there are any adverse tax implications for your situation in doing it one way versus the other. You also need to title the LLC's assets in the name of the LLC. Okay, so the second factor is capitalization. If you do not adequately capitalize the company, that is a factor that weighs in favor of a court permitting a piercing of the corporate veil. In fact, some states even have a separate cause of action for piercing of the corporate veil based on undercapitalization alone. So what are we talking about here? Does the company have enough assets and income to pay its foreseeable obligations? Insurance policies can act as substitute capitalization for risks that are covered by such insurance policies, but insurance coverage will not help in all situations. For example, if you form an LLC, you cause the LLC to enter into an agreement of sale to purchase real estate, you never capitalize the company, so the LLC does not have the money to make good on its obligation under the agreement of sale, and it defaults, that's going to be a problem. Now, that does not mean that you have an ongoing obligation to make capital contributions as long as your operating agreement states you do not have to make capital contributions. You're not sucking an unreasonable amount of money out of the company based on the company's foreseeable obligations, and you have not caused the company to enter into any non-ordinary course transactions that the company cannot afford. A non-ordinary course transaction is something like a purchase of real estate for an LLC that owns and manages rental properties. Okay, the third factor is not adhering to the LLC's corporate formalities. However, this requires an understanding of what the corporate formalities of your LLC are. Oftentimes, clients assume that the corporate law concepts like the requirement to have annual meetings, record minutes from the meetings, and the like are also LLC requirements. And I get it, it is confusing. After all, they are called corporate formalities. However, generally speaking, LLCs have the corporate formalities that are included in the company's LLC agreement or operating agreement. That is certainly the case for Delaware LLCs. At least in the case of Delaware LLCs, if there is no requirement for member meetings in the LLC agreement, you do not need to have them. Let me illustrate this point with a story. I had a client one time that came to me with a Delaware LLC agreement that he was convinced I would be impressed with. He gave it to me at our meeting and I started to review it. The first thing that I noticed is that the LLC agreement had 96 provisions. Now, sometimes there is a need for an LLC agreement with lots of provisions like this. However, this particular client was a fairly small-time real estate investor with an LLC owned by him and his wife, which is not one of those situations. The next thing was that the overwhelming number of provisions started with the members shall do this or the members shall do that. So I proceeded to ask, are you doing this? And he would say, no. Are you doing that? No. How about this? No. And this went on for about 12 provisions, and the answer was the same in each case. So here is a situation where the client could have had an operating agreement that placed very minimal obligations on the members and made it easy for them to adhere to their corporate formalities. Instead, the members had tremendous obligations and were not doing any of them. This is one of the reasons why I say that you need an operating agreement that is tailored to your situation. Fraud is the next factor that we're going to discuss. Importantly, for Delaware LLCs, there always needs to be a showing of fraud in order to pierce the corporate veil, whereas in most other jurisdictions, fraud is just a factor along with all of the others. That is one of the many reasons that Delaware entities are preferred to entities in other states. Now, fraud for purposes of piercing the corporate veil is not the same as criminal fraud that you may be more familiar with. Sometimes if there is a total and utter failure in one of the other factors, that could rise to the level of fraud for piercing of the corporate veil purposes. Let's use an example. If you recall, commingling assets and liabilities is one of the factors. If you do not have a bank account for the LLC and you use your personal checking account to collect all income and pay all the LLC's liabilities, and you title all of the assets of the LLC in your personal name, this may be enough to satisfy the need for a fraud showing. Okay, before we move on, one tangential note here. Please do not confuse the IRS's rule that it will allow you to disregard a single member LLC for federal income tax reporting purposes and allow you to include the LLC's income and expenses on your personal tax return. That is a completely different issue than what we are discussing here, and it doesn't override what I am saying. Regardless of what the IRS says, you always need to treat your LLC like it is separate and apart from you and all of your other companies, except for this one narrow federal income tax reporting rule. The last issue we're going to discuss is identity confusion or unintentional representations. These are not factors in piercing of the corporate veil, but they are some other legal concepts that could be used to shoehorn you into personal liability here. Therefore, you always want to be sure that the parties know that you are acting as a representative of the company. That is, when you sign your name on a contract and when you're communicating with parties. Please be sure your title and the company name appear on the contract you're signing and that your signature indicates you are signing as a representative of the company. We actually have a separate video on how to do this properly. When you send emails, be sure to list your title and the company name so it is clear you are representing the company and not representing yourself personally. Avoid statements like, "You know that I'm good for it," "I always pay my bills," "I promise I will pay this next week." Instead, the company is good for it. The company always pays its bills. The company will pay this next week. Avoid using the word partner to describe the other owners or other parties you're working with. Partners in a general partnership and general partners in a limited partnership have personal liability for the debts and obligations of the business and their other partners when performed in furtherance of the business. So you do not want to inadvertently send the message to a party that you are somehow personally on the hook or that you're in a partnership, which could mean that all the partners are personally on the hook. I hope you have found this episode on how to maximize your asset protections with your LLC helpful. Again, please kindly hit those like and subscribe buttons so we can keep bringing you valuable and profitable content. With that said, thanks for watching, and I'll see you next time.